14th October 2025, Insolvency and Bankruptcy Board of India has actually notified two amendments, one in the liquidation process regulations and the other into CIRP regulations. Both these amendments having the same impact, that the sale of corporate debtor or sale of the company as a going concern during liquidation process is over. It has been completely withdrawn. It has been withdrawn in view of that proposed amendment in IBC Amendment Bill 2025, where it is provided that another opportunity can be given if the application for liquidation is pending before NCLT. In this episode, we will see what is the impact of this amendment, and that too sudden amendment. What will happen to the existing processes which are ongoing? What will happen to already where the COC has already approved this? For all this, what is this episode? Today's episode will cover that.
So this subject is a very important subject. 7 years is the timeline roughly when this sale of the company as a going concern and sale of business of the company as a going concern was an established regime, and it has been changed. We all would want to understand what are the implications of this change, and that is what this video is about. Looking at the journey, why it started, looking at why it is finishing, and also very importantly looking at the implications on the existing processes, whether CIRP or liquidation.
Welcome to 185th episode of AAA Weekly Webinar Series. As usual, we will come with very latest concept or issues. In this episode, we are discussing the entire regime of sale of corporate debtor as a going concern during liquidation process, how it started, the evolution, judicial pronouncements, and finally the withdrawal, and how it will impact the existing processes. All those processes which are already started. And there are some difficulties, challenges. That is what we are going to discuss today.
So we have this regulation change where we simply have the concept deleted from all the places where it was introduced. So in case you look at the liquidation regulations which are on the screen, you will see that the two concepts under mode of sale, that is regulation 32, which allowed for sale of the company as a going concern and which also allowed for businesses owned by the corporate debtor as a going concern, have been removed. Other references to these provisions have also been removed, whether it is regulation 31A. We also see corresponding changes in CIRP regulations. In CIRP regulations, we have regulation 39C, where the requirement was that when the company is being put to liquidation or liquidation is being agreed on by the COC members, then the COC members agree as to how the company's liquidation will happen. A series of decisions are required to be taken by them, including budgeting for the liquidation process cost, selecting the liquidator, deciding the fee, also looking at whether they want a company as a going concern to be liquidated, whether they want liquidator to first pursue company as a going concern, and whether the COC wants the persuasion of or the possibility or checking the possibility of section 230 under Companies Act. This is what all has been part of the CIRP regulations for liquidation decision to be taken. The entire regulation which provided for the possibility for the COC members to ask the liquidator to pursue liquidation as a going concern first has been removed and has been deleted.
Regulation 32 of liquidation process regulations, which has sub clauses from A to F, So the clause number E and F has been completely deleted. What the clause number E says, the liquidator may sell the corporate debtor as a going concern. So this clause has been deleted. That means the liquidator cannot sell the corporate debtor as a going concern. Second, the clause F, it says the liquidator may sell the business or businesses of the corporate debtor as a going concern. So this is also deleted. That means the liquidator now has no power to sell the business or businesses of the corporate debtor as a going concern. However, there is a proviso. Now the proviso says where an asset is, so the proviso also says however, this amendment applies prospectively. That is, to cases where liquidation by sale as a going concern had not commenced. So that means wherever liquidation as a going concern has commenced, it will continue. So we will discuss in detail what could be the meaning of liquidation as a going concern has commenced. We will discuss in detail. However, for the time being, we will actually come to the other amendments, and that other amendment is in Regulation 32, Regulation 32A, which entirely deals with sale as a going concern. Regulation 32A is completely deleted from the liquidation process regulation. So the entire process which was explained in that Regulation 32 capital A is deleted. In the meantime, the CIRP regulations also amended, because in CIRP regulations there is a Regulation 39 capital C which empowers committee of creditors to decide whether the liquidator will keep the company as a going concern or not, whether the liquidator will try to sell the company as a going concern or not. That has also been deleted. So whereas in the case of Regulation 39D, means capital D, when this fee of the liquidator was discussed, and there was one part which also discussed about the fee of the liquidator during that period, that the corporate debtor is kept as a going concern, that is also deleted. Now let us understand the impact of all this. So when we say impact of all this, so this is one important part, is how do we say that the liquidation as a going concern has started? When we say that, then we will have to see what is the beginning of the concept that the liquidator will or can sell the corporate debtor as a going concern during liquidation process. So the first is Regulation 39C of CIRP regulations, where the COC decides for the first time, when passing a resolution for liquidating the company or passing a resolution for resolution plan approval of the company, like in case the NCLT rejects the resolution plan and passes an order for liquidating the company, then at that time the decision of the COC would be that one, who would be the liquidator, two, whether the company would be kept as a going concern or not. So the first decision whether the company would be kept as a going concern or not, that comes from Regulation 39 capital C of the CIRP regulation. So in any case, if this regulation has been passed, therefore we can always say that the concept of keeping the company as a going concern or selling the company as a going concern during liquidation process has started. Although there may be challenges, there may be applications or appeals against this concept. Secondly, when NCLT passes an order liquidating the company, also can direct the liquidator to keep the company as a going concern and also to endeavor or make efforts to sell the company as a going concern at the first instance. That also can be considered as the liquidation sale, or sale of the company as a going concern during liquidation process has already started or has already commenced. Third is as per the regulation 32A. 32A very clearly says that in case the COC has not taken a decision as per regulation 39 capital C of CIRP regulations, then the liquidator can also decide with the consultation of stakeholders consultation committee that the company may be sold as a going concern during liquidation process. And if the committee has also decided and the liquidator has also decided, that also would mean that the company has already started the sale as a going concern during liquidation process. So there are three possibilities. One, under regulation 39C of the CIRP regulation. Two, an order from NCLT while passing the order for liquidating the company. Three, under regulation 32 capital A, when the liquidator decides to, with the consultation committee, to sell the company as a going concern. So these are the three basic events which actually can decide whether the process of sale has started or not. In case it has started, then the withdrawal of these regulations would not impact the process, and the liquidator is expected to complete the process of sale of the corporate debtor as a going concern during liquidation process, and this withdrawal will not impact that thing. So this is what is our understanding, and there is a possibility that the court may give a different opinion. However, this is something which is important. But while we are saying so, we can also ask Ankit to say something about the evolution of the concept. Can you say something how this process of sale of the company as a going concern during liquidation process has started? Any kind of history that we can see about it?
When we look at the evolution of liquidation of the company as a going concern, we have to go back to the Irani Committee Report 2000. And this report, which was published in 2000, we could see was the first such document which recommended liquidation as a going concern. In case we look at para 7.5 of this committee's report, we find that it says that the tribunal shall have the power to direct the sale of business of the company as a going concern, or at its discretion to sell its assets in a piecemeal manner. Subsequently, we do have an amendment in section 457 of the Companies Act, which later mirrored section 282 of the Companies Act 2013. Both empowered sale of the company as a going concern. So section 282 subsection 2 says how the tribunal may or allows the tribunal to, on examination of the reports submitted to it by the company liquidator, and after hearing the company's liquidator, creditors or contributories or any other interested person, order sale of the company as a going concern or its assets or parts thereof. So this is the second stage where we find some evidence of which allowed for company or company sale as a going concern. In winding up proceedings also, we see that the Honorable Supreme Court of India on 26th of September 2000 had in Allahabad Bank versus ARC Holdings Limited allowed official liquidator to advertise the sale of the company in liquidation judgment debtor as a going concern. So these are the precursors before insolvency started. When insolvency started, we do know that the original IBC code does not have any provisions for liquidation as a going concern. The first part came in when the Insolvency Law Committee, in their report dated 26th of March 2018, recommended and said that the phrase as a going concern implies that the corporate debtor would be functional as it would have been prior to initiation of CIRP, other than the restriction put by the court. To clarify this Insolvency Law Committee again did not foresee liquidation as a going concern, but talked about how During CRP, the company or the corporate debtor has to be maintained as a going concern and talked at length about what is that going concern. It was only in the amendment dated 27th of March 2018 that we first saw insertion of the term sell the corporate debtor as a going concern in Regulation 32 of the liquidation regulations, allowing for this provision. We then had another roundtable on 21st of May 2018 where discussion was held between stakeholders referring the case of Gujarat NRE Coke Limited, where it was discussed that what are the issues in implementing liquidation as a going concern. And after that, another amendment was made, which of course changed more details about this process. That amendment was actually dated 22nd of October 2018. And on that date, this Regulation 32 was again changed to provide for both sale of the corporate debtor as a going concern and sale of the business or businesses of the corporate debtor as a going concern. We do see another judgment which was given by NCLT in Alchemist Asset Reconstruction Company Limited versus Abhijit MADC Nagpur Energy Private Limited. Here again the bench clarified that when sale is to be made as a going concern on a going concern basis, then certainly after the transfer of undertaking, acquirer gets all rights, titles, etc., etc. So here again, this judgment had come after all these amendments had been done in the regulations where it allowed for this process. Now, this of course is the journey to find how the liquidation as a going concern started. It further got strengthened in the amendment in July 2019 when we had Regulation 32A coming in, which talked about the sale of the corporate debtor as a going concern at length, also talking about the various details and the various reliefs or the various changes or the various process that is required to complete this. We then had another amendment in 2019 which introduced Regulation 39C requiring the COC to take a decision on whether the liquidator is required to first try and sell the company as a going concern. We also had other amendments in 2022 and 2024 which talked about this sale of the company as a going concern. We can now discuss that how this got reversed. We see the journey on how this became the law, how we understood that sale of the company is possible as a going concern in liquidation proceedings, and how we see the journey where now it is coming to an end. So what is your experience with respect to, if you can share some experiences where what might be the reasons why this has been put to end? One reason that I understand is that many times we understand that people find it difficult or time consuming to go for a resolution plan and they wait for the company to be sold as a going concern during liquidation. Is that the main objective of this change, where we simply see this getting deleted so that anyone who wants to buy the company as a going concern will have to take it through a resolution plan?
So what prompted this amendment? Primarily, the Insolvency and Bankruptcy Code is for resolution, for resolving the stress of the company, and everything remains the same. The workers continue, employees continue, customers continue, the productivity continue, infrastructure remains intact, but the owner changes and the stress comes to an end. That is what is the primary objective of Insolvency and Bankruptcy Code. While there is an option available for sale of the company as a going concern during liquidation process, there was a challenge on resolution processes. There was a feedback to the government that because of this option available, not many persons are coming for resolution process. Resolution process is little expensive. Participating in the resolution process is expensive. It may take longer time. It may be little uncertain. and even it actually may not be fitting into the timeline for acquisition of a company. However, in the case of sale of the corporate debtor as a going concern in liquidation process is very quick, less time consuming, just participating into the e-auction and then it is all yours. You make the payment and you can take away the sales certificate. Therefore, the various committees, they in fact started discussing this concept that this option of sale of the company as a going concern during liquidation process is impacting adversely the resolution processes. The public at large is not interested in coming to the resolution processes. They wait for the liquidation process to start and so that they participate. In the first Standing Committee on Finance in 2020-21, in its 32nd report titled as Implementation of IBC Pitfalls and Solutions, which is dated 3rd August 2021, it recommended that Regulation 32, Clause E of the liquidation process regulations should be deleted. That was the first nail in this particular, in the coffins of this concept. It was discussed while liquidation under Section 54 of the IBC requires dissolution of the corporate debtor, Regulation 32 of the liquidation process regulations inter alia provides for sale of the asset of the corporate debtor during liquidation. So NCLT, the principal bench in the matter of invest asset securitization and reconstruction private limited versus Mohan Gems and Jewels Private Limited, has also taken a view that liquidation requires dissolution under IBC and hence regulations that provide for liquidation as a going concern are ultra vires and that the legislation has created further uncertainty. Therefore, Regulation 32, sub-regulation E of the liquidation process regulation may be deleted. Additionally, Regulation 32, sub-regulation F of the liquidation process regulations may be amended appropriately. So this was the report of the Standing Committee on Finance. Then coming to the report of the colloquium, a report of the colloquium on the functioning of and strengthening of IBC ecosystem, which was held in November 2022, and it was stated in that report that the code may be amended to enable committee of creditors to resolve the functional part of the business separately through one or more resolution plans and enables the unviable non-functional parts of the assets to be liquidated by allowing other modes of sale like slump sale, sale of parcels of asset or standalone assets during CIRP after the option for selling it as a going concern either in whole or part have not yielded result. In view of the above, there may be no need to provide sale of the corporate debtor as a going concern under Regulation 32, sub-regulation E of the liquidation process regulations. This may be deleted as recommended by Standing Committee on Finance on implementation of Insolvency and Bankruptcy Code Pitfall and Solutions. Further, the Insolvency Law Committee in February 2020 report said that the code provide a linear process for resolving the insolvency of corporate debtor. First, a CIRP is commenced during which the COC assesses the validity of the corporate debtor and viability of the corporate debtor and invites resolution plans. Only where the CIRP fails, the code provides for an entry to liquidation. Thus, liquidation has been envisaged as the state the entity enters at the end of an insolvency resolution process, where neither creditors nor debtors can find a commonly agreeable solution by which to keep the entity as a going concern. Therefore, entry into liquidation itself implies the inability of the corporate debtor to be continued as a going concern. Accordingly, the code prescribes dissolution of the corporate debtor as the final outcome of the liquidation process. The committee also noted that it attempts for reviving the corporate debtor as undertaken after a liquidation order is passed it may lead to delay and may also undermine the efficacy of the CIRP, which provides a time-bound period for reviving the corporate debtor. The committee agreed that it would be contrary to the scheme of the code to allow a corporate debtor to be sold as a going concern after the conclusion of the liquidation process, which envisages a dissolution of the corporate entity. Accordingly, the liquidation process regulations should be appropriately amended to prevent going concern of the corporate debtor sale during liquidation processes. The IBBI discussion paper dated 4th of February 2025 referred to all the above mentioned reports and proposed to delete Regulation 32, Subregulation E and Subregulation F for the following reasons. So that is basically the reason mentioned in the IBBI discussion paper was regarding the poor recovery, or basically having the adverse impact on the resolution processes. So therefore, these were basically reasons that this amendment has come. However, the work had started when the IBC Amendment Bill was introduced in Parliament. In that amendment bill, there was an amendment in section 33 of the code, and where the moratorium was also introduced in liquidation processes, and it was also a fresh provisions were in fact inserted, and those provisions in fact was very clear, and in fact this subsections 1A and 1B was inserted in section 33 of the code, which is to become act maybe in the winter session, permitting restoration of CIRP in exceptional cases even after a liquidation application is filed. So now presently there is a way that the company can be sold as a going concern and company can be revived, and there will not be any dissolution of the company even after the liquidation order is passed. Even after many years, the liquidation processes are continuing and some of the assets are already sold, and we can even sell the remaining part of the corporate debtor as a going concern. However, in this amendment bill, the amendment which is inserted, which is proposed to bring in, it says that in exceptional cases, there is a possibility of restoration of CIRP. So presently, Section 33, subsection 1 provides the following cases where the NCLT may initiate liquidation. 1. Where no resolution plan is received before the expiry of the insolvency period under Section 12. 2. That the plan approved by the Committee of Creditor is rejected by the adjudicating authority under Section 31. 3. The COC with 66% voting share resolved to liquidate during CIRP. Now, under the proposed framework, the NCLT may, on an application of the Committee of Creditors with at least 66% voting share, restore the CIRP if it is satisfied that no resolution plan was approved within the prescribed time, an approved plan was rejected under Section 31, and there remains potential for restoration of the corporate debtor. Upon restoration, the NCLT will either restart the process with a fresh timeline not exceeding 120 days, or restore it from the stage of invitation of resolution plans depending on the circumstances. Now, let us understand that this new provision which are being inserted in Section 33 of the code, it says that first of all, the Committee of Creditors has to make an application. Application can only be made if the liquidation application has not been approved and the court has not passed an order to liquidate the company. COC has to pass a resolution with 66% voting. COC must satisfy that there are possibilities of revival of the corporate debtor. And the COC also must say that yes, the liquidation application was filed. Number 2, there is a possibility of revival. And number 3, the resolution plans, in fact, there was no resolution plan which was approved during the CIRP period. Now, this is an opportunity which can be used to restore the CIRP even after a liquidation application is filed. One, that because of this new insertion of the code, it was pre-planned that this liquidation as a going concern concept will be completely deleted from the law. Secondly, this is considered to be a better proposition, that in case there is still a possibility of revival, then the CIRP can actually be restored. Now, this is the one, what prompted the amendment. Number two, what are the way forward? So the way forward is that one, that wherever the liquidation processes and the sale of the company as a going concern is already started, those will continue. Wherever it has not started, and wherever the COC decides that yes, there is a possibility of revival of the company after the Amendment Act is become law, then the Committee of Creditors can file an application to NCLT saying that there are possibilities of restoration, a revival of the company, so therefore the CIRP may be restored. So this is what is the way forward. So the one bigger question comes, now in case there is a company which is having a going concern status, the business is continuing, what are the obligations of the liquidator? Now the liquidator's obligation are in fact very clearly defined in section 35 of the code, which says, section 35 of the code says that it is the obligation of the liquidator to keep the company as a going concern, and in case the liquidator is keeping the company as a going concern for the purpose of better realization, then it will continue. If the liquidator is continuing as per section 35, the section 35, the powers and the duties of the liquidator says, subject to the directions of the adjudicating authority, the liquidator shall have the following powers and the duties, namely, clause E, to carry on the business of the corporate debtor for its beneficial liquidation as he considers necessary. So in case there is a company which in fact would be beneficial for the stakeholder to keep it intact means keep it as a going concern, continue with the business, the liquidator will have to do that. But if the revival of the CIRP is not agreed by the adjudicating authority, then we have other clauses where the liquidator can sell the company even as a going concern under other clauses of Regulation 32, and I will just bring to you the other clauses of Regulation 32, and that is to sell the assets in a slump sale or set of assets collectively, the assets in parcels. So the option of selling the assets in lump sum or in slump sale, where the entire company can be sold by way of an auction, a running company can be sold by way of an auction, and in that auction process document, it would also be considered that the assets and liabilities may be dynamic, and as on the date of the sales certificate, this can again be revalued, and accordingly the consideration will be paid. However, the sales certificate can be issued, but the corporate debtor would be dissolved, and the mode of transfer of various assets would be different. Now, in case I sell a company in slump sale, where I would actually transfer all the fixed assets, so that means for the purpose of land and building, I will actually be transferring by way of a sale, execution of the sale deeds or transfer of the leasehold rights under the Sale of Property Act. In the SEC, with regard to other movable fixed assets, I will use the Sales of Goods Act and I will issue the invoices. As regards the inventory, and I would actually use the again Sales of Goods Act, and I will issue invoices by the liquidator to the buyer. As far as this other receivables and other contractual rights are concerned, that can be assigned under the Contract Act to the successful bidder, and that way the current liabilities can also be transferred or assigned to the to the successful bidder, but the company would be dissolved. The company would not continue. In case there are any trademark, copyrights, patents, all those can be sold, but the mode of sale would be different. For depending upon the item to item, it would be sold. Depending upon some of the liabilities also, in case some of the current liabilities which are dynamic liabilities, those also can be assigned to the bidder in case we make it as a part of the process document or sale document. So one, that the liquidator will continue to keep the company as a going concern under section 35, it is an obligation of the liquidator. Number two, the liquidator can sell also as a total company to a bidder through an auction process. However, the process of transfer, the mode of transfer of all the assets would be different, as I have already explained, and the sales certificate, over and above the sales certificate, all these documents would be issued, like the document of transfer of property, document for transfer of movable goods, document of transfer of the inventory, document for assignment of contractual rights or receivables, and documents for the transfer of all trademark motor vehicles. Everything can be transferred according to different law in this country. So therefore, this is possible to maintain a company, keep a company as a going concern, and sell a company as a going concern. So even if we withdraw this concept, however, the liquidator is under obligation to keep the company as a going concern, and liquidator also may sell the company in under clause I, under clause the assets in a slump sale or assets in parcel that can be sold by the liquidator. So as far as this impact to the liquidation processes are concerned, it's not much. So the entire era, this regime started in 2018 after this Gujarat NRE Coke case. So the first amendment that we saw for sale of the company as a going concern, that came in 2018, and thereafter it was only the amendments to facilitate this. However, when the adverse opinions started in 2022, and thereafter finally the adverse opinion of various committees, and also because of the feedback that the sale of the company as a going concern is impacting adversely the resolution processes. So therefore, this era has now ended completely. No new cases would be approved for sale of the company as a going concern, provided you prove that it commenced much before 14th of October 2025. In case you are able to approve, then NCLT may consider approval of sale of the company as a going concern. Otherwise, 14th October 2025 is a dead end. However, there may be a new avatar which will come after the Insolvency and Bankruptcy Code Amendment Bill 2025 is approved by Parliament. But that also would be restricted, that unless the order for liquidation is passed. If the order is passed, then that option is also not available. That option is available only if the liquidation application is filed and the committee of creditors thinks that there is a possibility to revive the company. So they can actually file an application with a prayer that in fact we would like to restart CIRP, and the NCLT may give it for 120 days, and it has to be closed within 120 days. This amendment, the withdrawal, it is only because to promote resolution processes, and to my understanding, it is much better for the resolution processes. Otherwise, the public at large presently feels that the participating and acquiring the assets or companies in a liquidation process is easier, it is much less expensive, and it is certain. Whereas acquisitions through a resolution plan is expensive, time consuming, and uncertain. With this amendment and with many other amendments which are proposed in IBC Amendment Bill, I feel that the coming era is the era of resolution plans and not for liquidations. Thank you.